The beauty of generative AI is that you can give it text or photos or something else, video, and it can analyze it, and then it can create something else. This is the issue with AI. It's not another person. It doesn't actually understand you. It's using statistical analysis to get to the end result, because someone is going to put in a prompt and they're going to get a result that incorporates the information that you fed into the AI model. And that could be your client's confidential information. You're going to find that software code is written by AI. And so the code itself right now is not protectable by copyright.
Welcome and thank you for all joining us for another Justia webinar. My name is Nina and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker today, Joshua D. Waterston. Joshua D. Waterston practices technology, intellectual property, and business law at WilfTech LLC with a focus on enabling business owners and entrepreneurs to prevent or resolve legal issues. He has represented clients in licensing and transactional matters, in federal copyright, trademark, and patent infringement litigation, and has protected clients' rights before the Copyright Office in the United States Patent and Trademark Office. He has handled civil and criminal litigation from trial through appellate stages, having litigated well over 30,000 cases in 2 decades. Now, the webinar presentation that you're about to watch today will be approximately 1 hour, and Joshua will be taking questions from the audience at the end of the presentation, time permitting. If you'd like to submit a question at any time, you can do so by clicking the Q&A button in the control panel at the bottom of your screen and sending them in there. Now, without further ado, here is Joshua to discuss AI in Your Legal Toolbox, smarter strategies for safeguarding clients' IP.
Thank you so much, Nina. It is a pleasure to present on behalf of Justia. So here we go. And I will say Justia is terrific, and I've had great experiences. So I look forward to presenting this, and I recommend that everyone here sign up for everything Justia has to offer. There we go. Starting off, here's the agenda. We're going to talk about, first of all, setting the stage. What is AI? You may think you know what AI is from a specific angle, but I've done many presentations regarding AI, and it changes about every 5 minutes. So you may learn something, hopefully, about that. There are ethical requirements. Those are also changing. AI in court, that is probably changing faster than anything, because courts and litigants, counsel are all grappling with how to use AI efficiently, but also accurately. AI uses for lawyers, again, you're going to see a theme here, changing rapidly. My firm is looking at different tools to use, and the offerings have changed extremely fast. So I'll give you the up-to-date information that I know. And then kind of switching from just the lawyer's point of view to perhaps the client-specific point of view. How do you protect your client's intellectual property rights? Both using different types of IP law and also through contract protections. And then hopefully we'll have time to kind of look around the corner and see what's coming up next. So starting off, what is AI? You'll hear people talking about AI, and they generally will mean generative artificial intelligence. Well, that didn't just start in a vacuum. Give it 50, 70 plus years that this has been going on. But in the modern era, it's really machine learning. And machine learning is where a business can take an algorithm that's able to extract patterns from a large body of data, and it can quote unquote learn. So it's not using a rule-based algorithm. It can figure out what makes sense of this unorganized, unclassified data. What can we do with it? What are the patterns? What do we do next? So there are some examples: internet search results, recommendations for all the streaming services you're using and Amazon, all that, social media algorithms for better or worse, driving directions, um, uh, heartbeat detection, which I think is a fantastic uh, use, inventory forecasts. So all of that is machine learning. It's not AI. But then you get to actual AI. Well, how is that different than machine learning? Well, it's trying to take machine learning and use it, put a more human perspective on it. So if you look at the definition, a machine-based system that can, for a given set of human-defined objectives, make predictions, recommendations, or decisions influencing real or virtual environments. Artificial intelligence systems use machine and human-based inputs to do various things, such as Pac-Man Ghosts, which I didn't remember. I obviously played Pac-Man. Yes, I'm that old, but I didn't remember that it was actually one of the early types of AI. You may have heard of Deep Blue, which beat the current chess champion at that time. And then legal research has been using AI for a long time. But all of this is not the same as generative AI. Generative AI is basically AI and then creating content. So the beauty of generative AI is that you can give it text or photos or something else, video, and it can analyze it, and then it can create something else, either uh, analysis or a derivative document from that. So it's really a game changer, and it really hit the scene in, say, 2003 or so with ChatGPT 3.5, and we are now at 5. How does it work? Well, the technical version that you'll see on the left is from a bunch of Google researchers who wrote a paper a long time ago, back in 2017, and this was part of it. The less technical version is that the computers analyze the content of words or pieces of words and the position of words in relation to other words. And because AI models are trained on so much data, this statistical analysis is pretty accurate most of the time, keyword being most. And they can figure out, so if you say, who was the first president of the United States, it'll probably be accurate when it says George Washington. If you get into something very nuanced where there isn't a lot of accurate and current data, it may not be correct. It's going to really have to go out on a limb more because there isn't as much statistical data to use. So as you can probably guess, item 3, more data to train, more guidance can usually improve the accuracy of results. Although you've probably seen in the news that that's not always the case. So GPT is a generative pre-trained transformer. And that brings us to today. So what are the current uses of generative AI? Chatbots, okay, coding. So more and more companies are using AI-based coding such as Cursor or Replit to save time. And I've heard good things about it, even from coders. Then you have other types of AI, generative AI, images, where it can take a text-based prompt, maybe paired with an image, and create a different image. Video, where it can take text or photos or video and create its own video. Sora 2 came out and apparently is relatively impressive. Music and voice. There's AI-generated music. There's AI-generated audiobooks. So AI, like any other tech, is good and bad. So let's see an example of AI-generated images. If you look on the right, pretty self-explanatory. Not a difficult prompt. Hey, I'm presenting this webinar. Here's the title. Design an image in which a lawyer has successfully learned from my webinar and is putting the lessons into practice. So if you look at the small picture, it's not bad. But look closer. Okay, the text is not great. AI doesn't actually understand you. So AI in became AIN. If you look at the lawyer's hand, he snapped a tiny, tiny pen in half. Uh, Maybe he was upset at the CLA. He also put random things on the desk, judge's gavel, even though he's not a judge, from the picture. A book is sort of haphazardly situated. The letter size kind of trails off if you look at the word strategies. And then if you look at the corner of his eye, it kind of wraps around a little too far. So it's a little off. So this is the issue with AI. It's not another person. It doesn't actually understand you. It's using statistical analysis to get to the end result. Okay. With that, there are ethical requirements. You may have understood from seeing the news, from listening to this webinar so far, AI is not always accurate. It just isn't. And when it's not, it is called hallucinating. And that causes problems, especially for lawyers. So take your favorite joke about lawyers, but at the end of the day, lawyers are supposed to be trustworthy and honest, at the very least, to the court. I mean, I don't think it's great that there's a law saying you have to be honest to the, or ethical rule saying you have to be honest to the court, but it doesn't say that you have to be completely and utterly honest to everybody else, but you're really supposed to. However, when it comes to court and you're submitting something to a judge, for example, it really needs to be accurate. And if it's inaccurate, it needs to be despite your best efforts and despite your having used your experience and skill to figure out if you were making a good argument. So in support of this, to get to a good result, the Pennsylvania Bar Association and the Philadelphia Bar Association issued a joint ethics opinion in 2024. So about a year and a half ago, I was on the committee. I wrote part of the opinion, and I think it came out pretty well. It was pretty detailed. A couple months later, the ABA issued its own version of an ethical opinion on the use of AI. So those opinions they had a lot in common. So here are the rules of professional conduct that were cited by both opinions. And I'm only going to spend a few minutes on this. I could spend an hour talking about just this. Competence. Lawyers have to understand the technology and verify its output. So even though it's quickly changing, if you're a lawyer, you have an ethical obligation to understand what you're using, how it works, and you have to verify its output. Communication, you're supposed to get your client's permission to use AI, and they have to have eyes wide open. Confidentiality. Hopefully lawyers know by now, if you're putting data, client information into an AI system that is training on your data, you're breaching confidentiality because someone is going to put in a prompt and they're going to get a result that incorporates the information that you fed into the AI model. And that could be your client's confidential information. So I think it goes without saying that would be bad. Don't do that. We'll get more on this in a moment. Conflicts of interest, similar to the above. Make sure AI does not reuse one client's information to the detriment or benefit of another. Meritorious claims, candor to the tribunal, that should be self-explanatory. Supervision of lawyers. If you're the head of your office, if you're the head of a team, you have to make sure you know what your team is doing. You should set policies and enforce those policies. Supervision of non-lawyers. Well, AI tools are doing stuff and they are non-lawyers. And so you have to know what they're doing. You're responsible for the outcome, the output of their work. Misconduct. Passing along unverified AI output that you know to be false is dishonest conduct. So None of this should be that surprising, but it's very much worth reiterating. Something very important is free chatbots are probably training on your data. Now, August 27th, I think, is when I sent in the slides. And the slide had been titled, "The free version of ChatGPT is probably training on your data." Because at that point, Claude, which was Anthropic's AI offering, had a brand differentiator since 2023, where they said, look, it's important to us that we respect your inputs. We're not going to train on your data. This is who we are as a company. They ended up getting, I think, more venture capital funding, more investment, and well, August 29th, it hit the news that they were now just doing the same thing as ChatGPT, where the free version is going to, by default, train on your inputs and your outputs, most likely your inputs. You can opt out. $20 a month for both platform, for each platform. There's a setting where you can say, don't train on my data. And then if you're at an enterprise level, it will, by default, not train on your data. If you're using the application programming interfaces of one of these models, it will, by default, not train on the data, because otherwise no one would really use those models. So make sure you know what you're using, how it works, and whether it keeps your data confidential. All right, AI in core. Well, again, something I could spend another hour on. I'm going to just spend a few minutes here. There are certain requirements. There are definitely a bunch of cautionary tales. So one of the first judges to issue a standing order was Judge Bailson in the Eastern District, and that's where I am. That was 2023. And he basically said, I want to know if folks are submitting something that was prepared using AI. Self-explanatory. What's interesting is I talked to another judge in the Eastern District who had a counterpoint to that, which was, well, at the end of the day, the attorney is responsible for their own submissions and their own conduct. So if they were relying on a staffer, an intern, a first-year associate, or AI, they're still responsible for checking the work and making sure that they know what is being submitted and that it is accurate and worthy of submission. So from that standpoint, maybe you don't need a standing order. So the jury's still out on that. Courts are already using AI tools. Ross versus United States was the District of Columbia Court of Appeals. They referenced the 11th Circuit, where Judge Newsom concurred and used ChatGPT to shed light on conflicting definitions of the word landscaping. And Snell, and that was the Snell opinion. Snell was also cited in an opinion where the court was grappling with whether and how much to sanction a pro se litigant whose brief was chock full of generative AI hallucinations. So courts are using AI, and more courts are creating policies for the use of AI by their staff and by judges. The Pennsylvania AOPC just put one out, I think it was a couple months ago, and it's a good policy. Here's one of the first cases that really hit the news about a lawyer being sanctioned for misusing AI, and it was called Mata versus Avianca. And you can see these screenshots at the bottom are from exhibits in the actual case when the lawyer had to, show cause to a very unhappy judge that what they were doing was not sanctionable. And in essence, in this case, ChatGPT said, yeah, what I'm giving you is correct. They're real cases that can be found in actual legal databases, such as Westlaw and LexisNexis. Well, and then it doubled down, as chatbots tend to do. So the cases were not real, and if they were, they didn't stand for what the chatbot said they stood for. And if they did actually stand for that, the codes themselves were not accurate. So it was just a big fail. Now, the lawyer at issue, I think it was the two lawyers, were sanctioned to the tune of $5,000, which doesn't sound like that much, but they also were nationwide news, unfortunately. And I feel bad for the lawyers involved because I'm sure it wasn't intentional, but it was and became a cautionary tale. Now, one would think that the word has gotten around. One would be wrong. February, here's an example. Big law, sanction over fake case citations. Morgan and Morgan certainly is nationwide. Goody law. And so, big law really, or even medium-sized law, really needs to get the word on this, that you need to check these citations. Cam L. Gates and Ellis George, the judge was unhappy. That's understating it. The judge was just unhappy. I have a quote here, directly put, plaintiff's use of AI affirmatively misread me, et cetera, et cetera, et cetera. If the judge hadn't looked up the decisions, they may have come out with the wrong outcome. So, these are problems, and judges are becoming unhappy. So don't be the next example. Now, as I say that, I go to the next slide, which is more lawyers are becoming the next example. You would think that since 2023, the numbers would go down. There's a database, and this person who's running this database, I commend them for keeping it up to date. I have a link in the slide. But 2023, AI was not being used much, generative AI, by the public or by law. I think that these higher numbers are because use has increased. So, unfortunately, 2025 was a banner year for lawyers being sanctioned, which is problematic. I have a pull quote here from one of the cases in July. If fines and public embarrassment were effective deterrents, there would not be so many cases to cite. So Mata versus Avianca, despite being nationwide news, did not result in lawyers not using fake citations. Okay, what are some good uses of AI for lawyers? I've broken these out by category. There are hyperlinks in the slides that you'll get. It's important to know that these are changing rapidly. General legal research, co-counsel. There was case text. It was bought by Thomson Reuters. I believe that's what became co-counsel. LexisNexis has AI. LexisNexis AI. Bloomberg Law has an offering, Hebia. These are generally targeted at larger firms, and the price is matching that. General brainstorming, organizing, asking questions, which you can do as long as you keep it confidential. Make sure that the chatbot is not training on their client's data. The standard ones everybody knows about: ChatGPT, Claude, Gemini, Copilot. Document analysis and drafting. This is an area that's changing extremely rapidly. Harvey, which I believe is more in the big law space. Spellbook, which I think was more broad-based. It's now targeting at least mid-tier, and I think they're trying to get more into big law. My firm had a demo recently, and the pricing was much higher than what it had been, I think, a couple of years ago. Screens, which is another one that I recommend looking at. There's Diligent. Sana, I think, is also more big law. Pinsights, Ironclad AI. Depending on the size of your firm, depending on what you're doing, you need to find something that fits for the price that works for you. Practice management. Clio, which has been around for a while. Veritac, Supio. These can help firms accomplish certain specific goals. E-discovery, Relativity, um, Cecilia Epic. Big firms are incorporating AI into their platforms. There are also smaller firms incorporating AI, but I only have so long on the slide. Litigation strategy. There's several down here. I recommend looking at them. Uh, Generative AI tools are changing e-discovery. They're changing litigation. Um, they're changing IP law specifically. And let's get to that next. So when it comes to intellectual property law and practice, AI tools seem to have hit the patent practice space more than any others. Um, Claims drafting, checking prior art, things like that. And there are a bunch of different offerings. So if you're a patent lawyer, AI may be right for you. Check with your doctor, see if AI is right for you. Anyway, novelty checker, see above. Trademark searching. There isn't as much AI, much in the AI offering space for trademark. And what there is it's good because it's wrapped into the platform that you may be using already. But there's an argument to be made that you could use ChatGPT or Claude to look up certain information, but you just have to check it. Because if you ask AI and it says, yeah, no one's gotten to this mark, uh, you're safe. Well, I wouldn't really go with that. I would make sure you check with the trademark office, but it's good to get a sense of maybe brainstorming, maybe a first check. Transcription. There's multiple offerings in the transcription space. Very important. There are several states, I forget the exact number. I want to say 7. I could be wrong. There are several states that require the consent of everyone who's being recorded. So when you came into this Zoom, there was hopefully a screen that said, this may be recorded. Other people may have the transcript. And by continuing to use it, you've consented. It's becoming more frequent that on meetings, that I've seen, there will be someone with an AI transcriber. And often the meeting lead will say, everybody okay with this? Anyone who isn't, let me know. And if the person who's using an AI transcriber says, you know what, I want to make sure I capture everything, or I have difficulty concentrating on what I'm doing in the meeting, but also taking really good notes, everybody okay with it? Well, maybe it's fine to be recorded. If you're having a legal negotiation and you want to be free to be in the flow of that without it being recorded for posterity, maybe you don't want it to be recorded. What are the risks of using AI? Well, it hallucinates, makes stuff up. It can disclose confidential information, output biased conclusions, and introduce cybersecurity risks. The legal landscape is new and uncertain. Can AI results be trusted? Well, you probably know the answer already, which is maybe, maybe not. You need to check the results, period. There are 2 quotes here, and I think they both go to show that the more important the thing is that you're relying on AI for, the more essential it is that you check the accuracy of the output. What are other risks? Well, you saw on the prior slide. Disclosure of confidential information, cybersecurity risks. If the person using AI has the ability to put in information that they really shouldn't be putting in, an easy way to resolve that is to change their access to that information. So what companies and firms should already be doing would stand them in good stead with AI as well. Make sure that people have access to the information that they need for the work that they're doing. If they have access to too much information, and that information can get into an AI model at the expense of your clients or your firm, you're really doing yourself and your firm a disservice. And you'd probably have to explain that to a judge at some point, and the judge would not be overly excited. Factual and temporal bias. Well, if the data set is too broad or too narrow and hasn't been updated or is based on human biases, the output is going to reflect that. Garbage in, garbage out. So, and in addition, it can expose companies to liability. So last year, Derek Mobley filed an employment discrimination lawsuit against Workday, basically saying that their algorithm-based applicant screening system discriminated against him based on, and others based on race, age, and disability. There are other lawsuits against companies accusing them of similar bias. So, this is still early days, and we'll see what happens. But if you're looking for the low-hanging fruit to protect yourself, your company, your firm, one way is you need transparency. You need to know what has been used, how it works. Is it biased? How could it be biased? How do you prevent it from being biased? In the broadest sense of the term. Uncertain regulatory landscape. Every state this year has introduced AI legislation. There's no federal legislation yet, but there's a plethora of state legislation. So stay tuned. Now, how does AI impact intellectual property rights themselves? Okay, we're going to spend a bit of time on this because it's important. We've talked about IP, about AI affecting legal practice. AI also affects intellectual property law itself. So, starting off, well, what are the intellectual property assets you're focusing on? Who owns them? Are they licensed properly? What's the value? Is it what the parties expect? Can the assets and the status of the assets expose a party to liability? What are the types of IP that are really most affected by AI? Okay, so let's go into the types of IP. Well, copyright, patent, trade secret. Okay, folks may or may not know, copyright, at its essence, it protects original works of authorship fixed in any tangible medium of expression. It gives the author the right to monetize their work, with some exceptions, such as there's fair use, etc. The Copyright Office has issued guidance on the use of AI and the ownership of, the copyrightability of works that were created using AI. Patent. I am not a patent lawyer. I can tell you that the Patent Office has issued guidance on the extent to which AI can be used as a tool in creating an invention, but it itself cannot be an inventor. So for more on that, look up the term Davis and Stephen Thaler. Trade secret should go without saying. If you know anything about trade secret, the essence of it is it's something that is so important that you're making an effort to protect it because it has economic value to you or your company. And that's what you're doing so that other people don't know about it. Well, Coca-Cola should not put its secret recipe into a free and public AI tool. That would be bad. A few years ago, Samsung made the news because some of its engineers put code into an AI tool, and it was trained on that code, and that code ended up becoming known to the public. Samsung was not happy. What does the Copyright Office say? Well, this year was the third of 3 reports about AI. In essence, AI cannot be an author. It can be a tool. Adobe Photoshop can be a tool for editing a photo, but it's not creating the photo. Now, this was the example I used before Adobe had AI built into it. So if you say to Adobe, take this huge section of the image and make it look kind of like this. Well, maybe you've taken yourself out of the loop such that AI is really the author. And congratulations, you've removed it from being something that you can protect with copyright. Now, if you take a small piece of the image and you say, this is green, I want it to be aqua, and you are very, very precise, and what you do is replicatable, there's a much, much better argument that the output is protectable by copyright because the AI was a tool. So, you know, you see the bullet where it says, as AI technology becomes more rote and predictable, the Copyright Office could change its overall policy. Now, there's a quote here that really goes to that. The extent to which you have control over the selection, arrangement, and content of the final output is really going to determine the copyrightability. And yes, they talk about Feist and the now outdated sweat of the brow doctrine. These are three examples, okay? Zarya of the Dawn, that was February 21st, 2023. That made news because it was not copyrightable. And Castanova's attorney did a great job of pushing back on the Copyright Office and saying, here's why it should be. And the Copyright Office said, no, we disagree. So Castanova got a registration for the work, including the text and the, quote, selection, coordination, and arrangement of text created by author and artwork generated by artificial intelligence, but did not get a registration for the what was a graphic novel. The next example is also by Castanova, and that was about a month later. Actually, it was the copyright record was created a month after the decision, and it really reflected what was established in the prior decision. And so Castanova got a registration on the input, but not the output. Now, they issued the copyright report, the third copyright report, on January 29th, I believe. A decision on a single piece of American cheese came out one day later. They had very good counsel from Big Law. And what they did, what Invoke AI did, was they wrote a white paper explaining the specific steps that they did that iterated on this image. They created a video of the process. So they showed their work, and they got a registration. And even though it's of the selection, coordination, and arrangement of materials generated by artificial intelligence, which is not that dissimilar from what Castanova got in the first example, because it's so specific, what is covered is pretty much the whole work. So it's a very different outcome. And by the way, Invoke AI was just bought by Adobe. So if you like the price of your Adobe subscription right now, I don't believe it's going to get cheaper, but it is going to have more abilities, and that's the benefit. All right, USPTO guidance. Patent and Trademark Office issued patent-related guidance. So the important part is in bold. Inventions created with the use of AI are not categorically unpatentable due to improper inventorship if one or more natural persons significantly contributed to the invention. Right? And then they issued a really terrific set of guidance, a group of examples. So when you get the materials, I highly recommend, if you're a patent lawyer, spend some time with the slide, click on the links, look at the examples. They are very helpful. Trade secrets. Well, okay, I've talked about what a trade secret is, but if you put a trade secret into an AI model and it's training on your trade secret, is your trade secret going to be secret for long? The answer, no. No, it will not. So do what you would normally do to protect an AI. assume that if you're putting it into an AI model that is training on your data, it's training on your trade secret. And it would be a powerful argument against whether it is categorized as a trade secret. So things not to do. Again, you can reverse engineer a trade secret. So, how to stop something from becoming known, don't put it into an AI model that's not protected. All right, patents can protect the invention of AI tools themselves. So, in essence, what's the takeaway here? You really need to take steps to protect trade secrets from going into the database anyway. What's another takeaway? AI is changing the value of assets overall. It used to be that software was valuable not just because you could license it, but because it was protected, whether by patent or copyright or trade secret. Not so much by patent anymore. Hardware also can be protected by patent law. Well, now things are a bit different. When you have Cursor generating code really quickly and making it possible for someone like me to create an app, for example, is it as important for that app to be protected by copyright? Or is what's important first mover advantage, licensing of the app to users? More and more you're going to find, and some huge companies are doing this, you're going to find that software code is written by AI. And so the code itself right now is not protectable by copyright. But the value of the code may not be in its copyrightability. It may be the fact that it hasn't been disclosed. The source code hasn't been disclosed to anyone. Maybe you're just disclosing the object code itself. Trade secret protection, contract protection. If you're preventing anyone from looking at or using the code, then that's the right outcome of protecting it, even if you're not protecting it by copyright. So basically, you need to look at this holistically. It's not just black and white. It's not just, I can't copyright the software, that's bad. It's, well, what is the value? What's the goal of protecting the software? Due diligence, similar to the above. If you create AI technology, you own that. If you create it using AI, well, you still own it. Can't protect it by copyright, but if you're protecting it other ways, it still has value. You probably don't own copyright in AI outputs, patents in AI output technology, in technology that was created by AI, trade secrets and data submitted to an OpenAI database. Your client can get sued, copying work, privacy violations, for anything where you're relying on the AI without checking their work. What's a risk? Training data lawsuits. This has been in the news over and over and over for the last couple of years. Creators are suing users of AI, platforms. The companies behind AI platforms are generally the ones being sued. So, New York Times, Universal, Getty, many artists and writers, and it's been a process. The court system moves slowly, and so what's happened is, in the last month, you've seen the first couple of settlements. Anthropic was a $1.5 billion settlement, and that was actually at the lower end per work, but they had some decisions come against them, which were the judge basically saying, well, was it fair use to train on these works? Maybe, but you didn't have license. That's only one aspect, one element of fair use analysis. The impact on the market work, we'll get to that later, folks. And the judge basically signaled that he was not overly thrilled about that element when it came to Claude's use. And I also think the judge did not like the fact that Anthropic used uh, pirate libraries to find works to train their AI models on. So, you know, plaintiffs had something to lose. Anthropic had something to lose. They settled. We'll see what happens in future cases. What are best practices? Well, excuse me. So there are things that you can do to protect your client through negotiation of contracts themselves. And contract law isn't the fastest moving area of law, but with AI, you need to keep up because yes, it is changing, and you do need to put in different clauses. You do need to take a different approach to negotiation for certain areas. So, first of all, know your input. What's the data that your client is putting into an AI platform? Are they violating laws or contracts or other requirements by sharing the data with an AI platform, any platform? What rights does each party retain or lose due to the input? So you really need to understand the process. And you need to make sure that everyone on your team understands the process and the impact of using the AI tool. Okay, that's input. What about output? Right? What is the intended result? Does this match what everyone's expecting and what law requires? Can you explain what's going on to someone else? Is it transparent? Is it replicable? Is it explainable? Who owns the output? Have you specified this in your contract? Are you sure that what you're assuming is accurate as far as who owns it? So if you're an investor, AI generated software is public domain. Okay, important to know. If you're a developer, and this goes back to kind of what I was talking about before, if you want first mover advantage, AI may be the way to go. If you want copyright protection, write your own code. So one compromise is that something that's the crown jewels, that's mission critical, is written by people. If it's something that's less critical and that's changeable if needed, AI could write it. But then you have to keep track of what code was written by whom, when, and all that. You just got to be very, very much aware of that so that you can explain it. Confidentiality. Very important. Identify each party's confidential information, permitted uses, methods of protection. This is fairly basic for confidentiality, but it remains essential. Keep source code confidential. Yes, I've hit on this before in this presentation, but it's really important. You have to understand the latest tools. Software engineers have to understand, be familiar with, and be able to use quickly the latest tools. It's really becoming standard for even experienced coders to use AI somewhere in the logistics of generating code. Did I miss a semicolon somewhere in this routine? Okay, right here. So it can save you some time. Current AI models excel at analyzing a huge amount of code and also creating the documentation that coders aren't often thrilled about having to take the time to enter, and then also refactoring it. So, and I've seen that as well. I've used AI to generate code and to update code that I've written, and it's getting remarkably effective. There's a difference even between ChatGPT 4.0 and version 5. It's really good at solving bugs. It can go through hundreds, thousands of lines of code and say, yep, here's your issue. And that's huge. It's a big efficiency gain. So if you don't use AI, you're giving up that efficiency gain and you're missing a business opportunity. So it's all about balancing. What's the benefit that you want? Do you want the benefit of being first to market, having code that's better than what you had, having better user experience? Or is it something that is 100% by people and transparent because people understand everything went into it and it can be protected by copyright. Best practices. General items are really at the fundamental, at the foundational level. Do you want AI tools to be able to be used to provide the services that are contemplated by the contract? Are the definitions that you're using in the contract accurate? If you're using the term large language model in your definition of generative AI, is that going to be accurate? Because there are small language models as well. When you can run AI on a cell phone, you may need to change your definitions, for example. AI tools can be prohibited. That's fine. Okay, makes sense if you want to protect your work. But what happens when everyone is incorporating AI into its own into their platforms? Google, Microsoft, Apple. How does that affect your contract rights and responsibilities? I actually had to address this in a contract a few months ago because the lawyer on the other side made a very good point to this. This was the point. And so we had to really fine tune the obligations and what were we trying to prevent. So it was in that case, AI-based tools were able to be used partially. Intellectual property, see above, define the essential terms. Who owns what? Who has rights to what? I'll give you my perspective. If a customer is entering its input and its prompts into the AI tools, it should own the input and the prompts and the output. Now, the vendor should own its platform and should own its underlying intellectual property rights that it already had. That seems to be a decent way of doing it to me. Again, can AI tools be used to create work product? If they can, you better be pretty specific as far as the copyright implications of this in the contract. Just like if you have a contract, many of you may have seen this in a work product clause. If something is not a work for hire, then the clause will usually say, and if it's not a work for hire, then it's automatically assigned, so that you get around the issue of it not being work for hire. Well, it doesn't really matter because it's being assigned anyway. So you're going to have language similar to this to protect the intellectual property rights, or to have the intellectual property rights that you want. It also makes a lot of sense to warrant that a vendor has the rights that it says it has to transfer ownership over the work product. Other items, warranties and indemnification. It certainly makes a lot of sense for from a user perspective, a recipient perspective, to require that the vendor warrant the quality of the output and say that it will actually meet the specifications it's supposed to, and that there will be a human in the loop to review the AI output. And that if there are problems, if there are hallucinations, other inaccuracy, that the vendor will inform the user and will mitigate that issue at their own cost. And again, similar to the prior slide, that the vendor has the required consents to provide the data in their AI tools. And they'll comply with all current and future laws, including privacy and intellectual property laws. I can't tell you the number of times I've seen a vendor push back and say, well, the laws are changing very quickly. And I mean, I get that. I absolutely get that. But then why is my client using your cloud service and relying on it if you're not going to warrant that you'll keep up on the latest laws and regulations? At least that's my response. From a vendor's perspective, if you can't be required to warrant that things will be 100% accurate, because that's not how AI works. It's statistics, and statistics may be 99.9999% accurate, but they're not going to be 100% accurate. And so you have to address that. Indemnification. Indemnification, if you're using someone else's service and you're exposing yourself to liability as a result, the other party should make you whole. That's indemnification at its heart. So the vendor, from customer's perspective, a vendor should indemnify for claims that the service, including outputs, is violating a third party's privacy and IP rights. Vendor should ask the user, the customer, to indemnify for misuse of it. Okay. I'm going to go pretty fast on this. I'm hitting the high points in the bullets. Basically, SLAs, you really do need to address SLAs, information protection, privacy. You need to know what's going in, what's coming out, who is going to have access when. Okay, looking ahead. Well, I do not have a crystal ball. I can tell you that a year and a half ago, there were 19 copyright infringement lawsuits in the US. As of June 30th of this year, there are 47. So this issue is becoming larger, not smaller. Algorithmic bias, I already addressed it in a prior slide. It was certified as a class action earlier this year. So that case is very much alive as of May. Actually, as of the end of August. In a state of Loken versus United Health Group, the case is moving forward. It's narrowed, but it's moving forward. So again, these AI cases some of them may have been knocked out, some may have been narrowed, but many of them are still alive and kicking. And you don't want to expose your client to that risk as a general matter. Let's see. Trends in state legislation, pardon me. There are 4 states that have passed comprehensive AI laws. They're all a bit different. I will say transparency is really going to be a thing in 2026. California's laws, effective January 1st, developers must post documentation regarding their AI training data. Large businesses must disclose use of AI to generate content and enable consumers to identify the AI-generated data. This trend is going to continue from what I've seen. I have a few examples from this database. NCSL is a very good database for seeing what state legislatures are doing. And I especially like the one where it says North Carolina has new law prohibiting individuals from using an AI-powered robot to stalk or harass other individuals, expanding current harassment and stalking laws. I would really wonder what that where that came from, what that call was to the legislator that resulted in that law. But you can't use AI to do something that you shouldn't be doing anyway. Trends in agency enforcement. One thing that is common between the last administration, the current administration, cybersecurity breaches are a thing. Improper use of AI systems are a thing. You don't want to be one of these businesses that paid out over $8 million total to HHS's Office of Civil Rights. What's next? Well, your guess is as good as mine. Here are a couple of quotes. Andrew Ng, founder of Google Brain, a few years ago, AI is the new electricity. It will transform every industry and create huge economic value. Well, that was correct. McKinsey, it's distinct. It's doing different things. The better the models are, the greater the risk. Yes, that is accurate. So human in the loop is hugely important. That's one takeaway I recommend. Know what you're using AI for, know how it's affecting you, your firm, your clients, and be prepared to change as AI and the platforms in the industry change. Thank you very much.
Yes, thank you so much for that presentation, Joshua. I really appreciate your time. All right, we can now move on to some questions. It looks like we've got a couple. So our first one comes from an anonymous attendee. They ask, how can IP lawyers ensure that generative AI models or tools used in their practice don't inadvertently train or expose that confidential data?
That's a great question. Two ways are: one, if you're using consumer grade AI tools, generative AI tools, make sure that you understand the settings. Make sure you understand how to switch off the ability of the platform to train on your data, on your inputs. So that is, low hanging fruit. Another way is use one of the tools that are built for lawyers, because those are made uh, using relying on the APIs, the application programming interfaces for the models themselves, and those do not train on your data. So that's the key for that piece of it.
Thank you, Joshua. Our next question is also from an anonymous attendee. They ask, given the evolving ABA and state bar guidance, what concrete steps can lawyers take to remain compliant when using AI for research, or how do you recommend they stay up to date on those things?
Huh. How much time do we have? Um, I would say, there's a reason that CLEs exist. Um, it's so that you can learn something that you may not have otherwise known, or if you know it, but you can find out what's the latest and greatest. Now you know that too. So stay up to date. I recommend Justia Connect Pro. Sorry, there we go. Um,
Thank you,
that's one answer. Just stay up to date.
Thank you, Joshua. Our next question is, as courts begin requiring disclosure for AI use, what are the best practices for actually documenting the AI assistance for filings to avoid sanctions or credibility issues?
Um, One way is have a firm policy, have a policy within your firm, um, where the policy is also firm, where where people have to document what they're using, when they're using it, and hopefully stating that they checked the work. Because if it's like, look, if I submit a trademark filing, um, I'm not verifying that the truth of the matter that I'm submitting. I'm saying that to my client to do. And so once my client signs off and does their own verification, I get it back and I can file it. So have the people who are doing the work verify what they did, when they did it. And so when push comes to shove, you can say, look, Judge, here's Bob, who'll be happy to explain to you what happened.
Thank you. And the last question that we have for today is, with the USPTO's stance on inventorship, what strategies can patent attorneys use to protect AI assisted inventions without violating current inventorship rules?
So um, I'm not a patent attorney, but I can say that I'm not always impressed by how the PTO handles technology. But in this case, I really am. Uh, when you get the slides, you'll have a link to their guidance page, or you can just do an internet search for USPTO AI inventorship patent guidance, and it'll come up. But they have examples, and it's quite good. It's better than anything I could say. So it's both detailed and and useful. Um, so that's one thing I would do.
Thank you, Joshua, for answering all of our audience questions and for your presentation today. And thank you to everyone who submitted questions. We always really appreciate your participation. We want to thank you all so much for joining us for another Justia webinar. As I mentioned at the top of our presentation, I want to remind you all of the services available to you through our website platform, Justia Elevate. It's our innovative, feature-packed website solution designed specifically for law firms. It includes tools like our Justia Justia AI Writer designed to help you create content for your website, our AI-powered Justia chat to help you enhance your leads, and newly added FAQs for AI to help you enhance your chances of showing up in those AI results. You'll have everything that you need to stand out online, and to check out the pricing for your firm's needs, you can go to elevate.justia.com/price. Thank you all so much for your time, and we hope to see you soon. Have a great day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.